Welcome back, dear students. Today we will see further ramification of the concept of equality as enshrined in Article 14. Today we shall be confining ourselves to the content of Article 15 and 16, and we will see how far Article 15 and 16 perpetuate the concept of equality mentioned in Article 14. In a sense, my dear students, Article 15 and 16 are further examples of equality. Articles 15 and 16 prohibit class legislation once again, as we have seen that Article 14 embodies the general principle of equality before the law. Its specific application is indicated in Article 15, which says that state shall not discriminate against any citizens on the grounds only of religion. See, only word is important. I have highlighted the word only in red color. I'm reading it again. State shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth, or any of them. Will be discriminated with regard to access to shop. If it is a question of access to shop, then state will not discriminate any citizen on the grounds only of religion, only of sex, only of caste, only of sex, or only of place of birth. For discrimination, there should be more than one ground. So, state shall not discriminate. If it is a question of access to shop or public restaurants, hotels and places of public entertainments, or use of well, tanks, bathing ghats, roads and places of public resort maintained wholly or partly out of state funds or dedicated to the use of general public. So while using all these items, state shall not discriminate against any citizen on the grounds only one of them. If there are more than one grounds, then they can discriminate. The word shop here includes a doctor's clinic and a lawyer's chamber. Doctor cannot refuse treatment of a person on the ground that you belong to a particular caste. I will not treat you. Similarly, a lawyer cannot refuse to take up the case of a client on the ground only of religion, race, caste, sex, place of birth, or any of them. This is prohibited. So a doctor or a lawyer can't refuse to entertain the client only on the grounds mentioned above. See this important case, Yusuf Abdul Aziz versus State of Bombay. The validity of section 497 IPC, that is adultery, in which wife is not punished as a better in adultery. The validity of section 497 IPC was challenged, and Supreme Court held that this section was justified because only you are punishing only male, not female. So Supreme Court held that section. Yes. So in Abdul Aziz versus State of Bombay, the validity of section 497 IPC was challenged because it discriminates between wife and husband. Only male member is punished for adultery, not the wife. Supreme Court held that this section was justified because discrimination was not based on the ground of sex alone. The exemption in favor of wife was made for other reasons also, such as that women in this country were married at a very young age and that their husband could have plurality of wives. So the discrimination was not based on sex alone. So sex plus something more were the grounds when this section was constitutionally held valid. And now you know the latest judgment on 497 IPC is Joseph Shine versus Union of India, decided by the Supreme Court in 2018. In this case, Section 497 IPC was declared unconstitutional by the Supreme Court. So, the present position, dear students, is that now adultery may be a ground in civil matters like divorce, but it cannot be a criminal offense. And dear students, when we talk about the other clauses of Article 15, like 15 clause 3, according to 15 clause 3, I'll start with it. So this Article 15 clause 3 is an exception to the prohibition contained in Article 15 clause 1 and 2. Clause 1 and 2 show that there can be no discrimination in general on the ground of sex, but special provisions in case of women and children are permissible. You see, under this clause, Article 15 clause 3, state can set up institutions exclusively for women and children. गर्ल्स हाई स्कूल अलग, बॉयज हाई स्कूल अलग, बच्चों के लिए स्कूल अलग. And girls can take admission in boys high school, but boys cannot take admission in girls high school because special provision is made for women and children. Similarly, section 64 of CRPC provides that if accused cannot be found at home and a service of summon is to be done, then service of summon on any male member can be effected. If you make a service on female member, it is not valid. Then you might raise a question that service of a summon on male is valid and on female it is invalid. This is discriminatory. But it is not. Exclusion of females is valid as a special provision under clause 3 of Article 15. And 497 of IPC is not invalid because it protects the modesty only of the women. And similarly, Section 125 CRPC, providing provision for maintenance of wife by the husband. But husband cannot claim maintenance from the wife. Again, appears to be discriminatory. But Section 125 CRPC is valid, although it obliges the husband to maintain his wife, but not vice versa. Similarly, children are prosecuted under Children Act 1960 or under latest Juvenile Justice Act and not under CRPC. So this classification between adult criminals and juvenile criminals is justified. So dear students, we have seen that Article 15 clause 3 is an exception to Article 15 clause 1 and 2. Then moving on, Article 15 clause 4 was added in Constitution of India by first Constitutional Amendment Act 1951. It says that nothing in this article shall prevent the state from making any special provisions for the advancement of any socially and educationally backward classes of citizens or for scheduled castes and scheduled tribes. This Article 15 clause 4 is the basis of all reservation policy in our country. And this article is an example of compensatory discrimination by affirmative action of the state, as also held in Indira Sahni versus Union of India, that is Mandal Commission's case, wherein the 27% reservation in favor of OBCs was upheld by the Supreme Court. But at the same time, dear students, please note, it was also held in this case that reservation is not permissible where high level of skill, intelligence, and excellence is required. Dear students, it was also held in this Indra Sahni's case that reservation is not permissible where high level of skill, intelligence, and excellence is required, like defense services, technical posts, specialties in medicines, engineering, atomic energy, space research, physical sciences, and post of professors, pilot, etc., where reservation is not permissible. Then, dear students, if you carefully read this Article 15, you will conclude that 15 clause 4 is also an exception to Article 15 clause 1 and clause 2, which was added by the Constitution First Amendment Act 1951. What happened in this leading case, State of Madras versus Champakan Deorajan? Supreme Court struck down the communal government order of Madras government, with which with the object to help the backward classes had fixed the proportion of the students of each community that could be admitted into state medical colleges. But the court observed that the directive principles of state policy could not override the fundamental rights secured to the citizens by Part 3rd of Constitution of India. In Article 15, the word used is socially and economically backward. And this backwardness must be both social and educational. It is up to the discretion of the state government to take suitable action if necessary, but it does not impose an obligation on the state. So, first Constitutional Amendment Act 1951 was passed as a result of decision of Champakan case, and Champakan's ratio decidendi was overruled by first Constitutional Amendment Act by addition of Article 15 clause 4. Then came another important leading judgment on reservation, that was M.R. Balaji versus State of Mysore, in which it was held that the caste of a group of persons could not be the sole test for ascertaining whether a particular class is backward or not. Why? Because backwardness under Article 15 clause 4 must be social and educational both. And it was also held in this case, M.R. Balaji, that reservation shall be less than 50%. It's not up to 50%, it is less than 50%. If there are 100 vacancies, then reservation shall be less than 50, that is maximum 49 out of 100. And dear students, a reservation made under Article 15 clause 4 of the Constitution should not limit the number of seats that may be available to the students belonging to backward classes under Article 29 clause 2. Backward class students can secure more seats than the number reserved, but not more than 50% under Article 15 clause 4 if by merit they are entitled to so. If by merit somebody from backward class is topping the entire merit list, then his seat has to be considered amongst the reserve category percentage only. He cannot claim benefit on both the sides, that a reserve category person, suppose he has topped the list, so his seat in the reserve category will remain vacant. No, his seat shall be counted towards his own quota. That is the position of law. Then Article 15 clause 5 was added in Constitution by 93rd Constitutional Amendment Act 2005. And this article says that nothing in this article, that is Article 15 and 19(1)(g), shall prevent the state from making any special provision by law for the advancement of any socially and educationally backward classes of citizens, or for scheduled caste or scheduled tribe, insofar as such special provisions relate to their admission to educational institutions, including private institutions, whether aided or unaided by the state, other than minority institutions referred to in clause 30, in Article 30 clause 1. यानी आर्टिकल 30 क्लॉज 1 वाले रिजर्वेशंस को माइनॉरिटी इंस्टीट्यूशंस को छोड़कर, if there are schools and colleges, even if they are private institutions, even if they are aided or not aided by the state can make reservation provisions by law in favor of socially, educationally backward classes of citizens. Then, dear students, moving on further, next Article 16 is also an example of application of general rule of equality before law laid down in Article 14. Article 16 clause 1 says that there shall be equal opportunity for citizens in matters relating to employment or appointment to any office under the state. Article 16 clause 2 lays down specific grounds on the basis of which citizens are not to be discriminated against each other in respect of any appointment or office under the state. The prohibited grounds of discrimination under Article 16 clause 2 are race, caste, so the prohibited grounds of discrimination under Article 16 clause 2 are race, caste, sex, descent and place of birth, residence, religion or any of them. Then, dear students, as you see minutely the language of Article 16, you will come to know that. So if you see minutely, you will find that Article 16 clause 3 is an exception to Article 16 1 and 2. An important point to be noted here is that 16.2 provides that no citizen shall on the ground only, again only word I have highlighted in the red color because only word is important. 16.2 provides that no citizen shall on the ground only of residence be ineligible for or discriminated against in respect of any employment or office under the state. Under Article 16 clause 3, Parliament is competent to regulate the extent to which it would be permissible for a state to depart from the above principle. It depends on the discretion of the state government that how much reservation they will provide. Then 16 clause 4, as we have seen, is another exception, and it expressly permits the state to make a provision for reservation of appointment or posts in favor of any backward classes of citizens, which in the opinion of the state are not adequately represented in the services under the state. Two conditions must be satisfied for application of Article 14. First condition is that a class of citizen must be socially and educationally backward. Second, the said class is not adequately represented in the services under the state. But please note down, dear students, that the limit of reservation as held in M.R. Balaji versus State of Mysore will also apply to Article 16 clause 4. That is reservation. So whenever there is a question of reservation, the limit of MR Balaji, that is reservation shall be less than 50%, will be followed, and this limit will apply to Article 16 Clause 4 also. Then dear students, you see Article 16 4 capital A was also added in Constitution of India by 77th Constitutional Amendment Act 1995. And according to this amendment, according to Article 16 4A, it says, nothing in this article shall prevent the state from making any Yes, dear students, according to 16.4a, nothing in this article shall prevent the state from making any provision for reservation in matters of promotions with consequential seniority to any class or classes of posts in the services under the state in favor of scheduled castes and scheduled tribes, which in the opinion of state are not adequately represented in the services under the state. See, initially the reservation was given in initial appointment. Now 16.4a is authorizing the state to give reservations in matter of promotion also. You have a reservation when you are appearing in the examination of civil judge junior division. But when you will be promoted from junior division to senior division or senior division to additional district judge, at that time also state may provide reservations to you in matter of promotion also, and then you will get consequential seniority also. This is a new addition by 77th Constitutional Amendment Act 1995. Then dear students, another clause, Article 16.4 capital B was again added in Constitution of India by 81st Constitutional Amendment Act 2000. And according to this amendment, the unfilled vacancies can be carried over in the next recruitment next year. Suppose out of 100 vacancies, 21 vacancies were reserved for scheduled caste in UP. But when examination was held, only 10 suitable candidates from scheduled caste category were selected. 11 seats remain vacant. Now when the next year again 100 vacancies will be advertised, again scheduled caste will get 21 vacancies out of 100, plus 11 left over from the last year also they will be entitled. And they shall not be counted towards the ceiling of 50% reservation. Because if you will count those 11 vacancies in next recruitment in favor of scheduled caste, then apparently you will see that percentage of reservation is exceeding 50%. But those backlog of vacancies are not to be counted whenever fresh recruitments take place. And the language of 14b is like this, that nothing in this article shall prevent the state from considering any unfilled vacancies of a year which are reserved for being filled up in that year in accordance with any provision for reservation made under clause 4a or 4 as a separate class of vacancies to be filled up in any succeeding years. So those unfilled vacancies can be treated as a separate class of vacancies also, and sometimes you see a special drive for recruitment of scheduled caste and scheduled tribe is being done so that the previous backlog, previous unfilled vacancies may be filled exclusively from that category whose vacancies are left unfilled. And such class of vacancies, जो मैंने बताया 11 vacancies were left, could not be filled. Such class of vacancies shall not be considered together with vacancies of the year in which they are being filled up for determining the ceiling of 50% reservation on the total number of vacancies of that year. पुराने साल की 11 vacancies को अगर आप नए साल में ऐड करोगे तो डेफिनेटली रिजर्वेशन आपको 50 के बजाय 60% दिखाई देगा. But that is not to be calculated in the next year vacancies. Those unfilled vacancies, they already belong to scheduled caste category. They should go to scheduled caste. This is carryover rule, commonly known as carryover. Then dear students, 16 clause 5 is one more exception to the principle of Article 16 clause 1 and 2. And this clause says that a law which provides that incumbent of an office in connection with affairs of any religious or denominational institution or any member of the governing body. फोन कर दीजिए खैर So the net conclusion is that Article 16 clause 5 is an exception to the rule contained in 16 clause 1 and 2, and according to this provision, a law which provides that incumbent of an office in connection with affairs of any religious or denominational institution or any member of the governing body thereof shall be of a particular religion or belonging to a particular denomination. Yes, you can say that head of the masjid will be a Mohammedan and head of governing body of Ram Janmabhoomi will be a Hindu. This is perfectly valid according to 16 clause 5. Then another clause, my dear students, 16 clause 6 was added in Constitution of India by 103rd Constitutional Amendment Act 2019. And this article says that nothing in this article shall prevent the state from making any provision for the reservation of appointments or posts in favor of any economically weaker sections of citizens other than the classes mentioned in clause 4, in addition to the existing reservation and subject to maximum of 10% of the posts in each category. So 10% reservation is given to economically weaker sections of the society, but they should be other than classes mentioned in clause 4. And clause 4 says that reservation can be made for socially and educationally backward classes of citizens or scheduled caste or scheduled tribe. So leaving the backward, leaving the scheduled caste and leaving the scheduled tribe, reservation can be given to economically weaker sections of the society. This means that this 10% reservation will go to economically weaker sections amongst the general classes. I'll mention it here. This means economically weaker sections amongst general category. This is the spirit of this amendment, that economically weaker sections amongst the general category should also get reservation. And this reservation has to be in addition to 50%. Now you will say that 50% limit of M.R. Balaji and Indira Sahni judgment is being violated. No, 50% are meant for those classes which are mentioned in 16 clause 4. That is socially and educationally backward, scheduled caste and scheduled tribe. We are not touching that 50%. This 10% EWS reservation is amongst the general category who are economically weaker. We are not touching that 50% yardstick. That 50% reservation remains intact. So dear students, you will see that we started from the concept of equality. All are equal before law. Then we started saying that likes should be treated alike and unlikes should not be treated alike. Then we started giving reservations to socially and educationally backward classes, scheduled castes, scheduled tribes also. Then we gave reservation to them in promotion also. Then we gave them consequential seniority also. And then we thought of giving reservations to economically weaker sections of the society also. And then we also made a provision for unfilled vacancies, that is carryover rule. So dear students, we started from equality and gradually came to exceptions tilting towards inequality. What is prohibited by Article 14 is partly allowed by Article 15 and 16. But in true sense, this shows that inequality is equality, where we are giving different treatment to different classes of citizens or groups. We are not giving the same treatment to all the classes. एक ही लाठी से सबको नहीं हाँक रहे हैं हम. We are giving different treatment to differently situated persons. And that is the real notion of equality, where likes should be treated alike and unlikes should not be treated alike. So thank you very much, dear students. Thanks for joining.